Good morning, good afternoon, good evening, and welcome to the Jerusalem Center for Public Affairs Daily War Room Update. We are on day number 115 of Israel's war with the Gazan terrorists. It starts on the 7th of October with the massacre of over 1,200 people, the kidnapping of 240 people, rape, pillaging, really tying members of the family together, burning them alive, really all types of despicable things that were carried out on that day by terrorists who left Gaza. I give that introduction because it is critical to understand as part of our further discussion for today. But as always, we will start with just the roundup of what's going on the different fronts so that we can present that picture and then move on to the discussion. In the Gaza Strip, the IDF forces are continuing to operate, really trying to continue to consolidate their stronghold in the northern Gaza Strip and expanding out operations also into the southern Gaza Strip through Khan Yunis and then eventually into Rafah and into all of the areas around there, Nusirat, Shati, all of these areas in the middle of the Gaza Strip and the north of the Gaza Strip, where Hamas had really embedded itself within the civilian population, placing rockets and missile launchers and munitions and really tremendous terror infrastructure in every place possible, in schools, in mosques, in nurseries, in houses, in every type of situation. They used the urban, the urban environment in order to ensure that they could fire their weapons and use those areas as launching pads for attacks without easily being discovered by Israel, and then B, to use the destruction of those areas as a cause to then further vilify Israel on in the international forums and in public opinion. What's been going on there over the last few days is really that the IDF is discovering more and more and more of this terror infrastructure. Today, a massive tunnel discovered and exposed running under Khan Yunis, under the cemetery in Khan Yunis, used by the senior Hamas terrorists and leaders as a place to A, hide, and B, actually live as they held onto the hostages for their use of them as human shields, in and of itself a war crime. On our northern front, obviously, we're not getting any rest either. Hezbollah is continuing to attack Israel. For those of you, I don't know if it's possible to download it abroad, or for those of you who are familiar with it, there is the Red Alert app on phones where you can really follow with all of these different firing of rockets and missiles and other all types of aerial aerial attacks on Israel, UAVs, and every half an hour, every hour, you will see another red alert popping up. What does that mean when you see that? It means that there's a siren going off somewhere in Israel. So last night, for example, many areas around the Gaza envelope were again being attacked by the Gazan terrorists. There, the launch of mortars, really closer weapons, continued on through the evening. Today, we've seen multiple events of flying objects, for want of a better word or better description, but really flying explosive objects penetrating Israel from Lebanon, sent by the terrorists and Hezbollah. In the south as well, we've seen the Houthis continuing on with interference with the freedom of navigation, that whole entrance into the Red Sea, Bab el-Mandeb, the Horn of Africa, and up towards the Suez Canal. Today, the Egyptians, our partners in peace from 1978, with an exceptional request from the Houthis, please restrain yourselves, only attack Israeli assets, but let everyone else go through because we need the income from the Suez Canal. Obviously, quite a legitimate claim from our close peace partners in the south from Egypt. It's those same people who have denied refuge on an almost 100% blanket across the board issue for denying refuge to any of the Gazans. Whilst they claim that there are terrible things going on in Gaza, this is the most highly and densely populated area where there's now an unprecedented military attack going on. And yet the Egyptians refuse to accept even one refugee from Gaza. The international community staying quiet, allowing the Egyptians to cause the deaths of Palestinians in Gaza, not really caring about them at all, rather wishing to use them as pawns and leverage in order to attack Israel. That's also part of what we're going to discuss further on. In Judea and Samaria and Israel today, two separate terror attacks, an attempted stabbing attack by Takar this morning, and then a ramming attack. That's a terrorist taking a car, driving into the population. He then got out of his car with a big axe and tried to murder a few more civilians there. That's what we're seeing today, and this environment. I have to say, the event in Israel was somewhat irregular in that it was, at least at the moment, the suspicion is that it was carried out by an Israeli Arab. That's something that we haven't seen happening so far in this war, which is now, as I said, on day 115. Having given that brief background and understanding of what's going on these different scenarios and different scenes, I have to introduce our guest. Today we're going to discuss really the what I call it's not a nice word, but I'm going to use it anyway. The debacle in the International Court of Justice. That's something which really has to be understood. South Africa claims that Israel is committing a genocide, and the court orders Israel to do sundry things. So we're going to discuss that today with really one of our experts that's coming on the program, Natasha Hausdorff. She's a barrister, an international lawyer, the legal director of UK Lawyers for Israel, and I would like to say also a friend. And together we're going to try and give you a little bit of an understanding, possibly a bit of a more balanced understanding of what went on in the ICJ. How did this case start? How did it progress? And where are we standing at the moment? What does it mean? Did the ICJ say that Israel is committing a genocide, as has been bandied around, or is it something less than that? What exactly is the story? Natasha, thank you very much for joining us, and thank you for really devoting some of your very, very, I know, very busy time to us in between appearing in court, arguing in court, interviewing on behalf of Israel, and going viral all over the internet. It's amazing that you could join us. Give us, Natasha, just a brief introduction. What happened in the ICJ? How did we get there? And from that starting point, and then we'll discuss possibly the legal presentations that were made just 10 days ago, and then the decision of the court after that.
Well, it's a pleasure to be with you. Thank you very much. I think the most important thing to start with is the order that we heard delivered and received in writing on Friday of last week. And the key aspect in which, as you have just trailered, it has been utterly misrepresented, even by, it seems, respected lawyers commentating on this around the world. And that's the first point that I want to pick up on. This bizarre assertion that on the basis of the order of the court on the 26th of January, there has been supposedly a finding that it is plausible that Israel has breached the Genocide Convention. Now, this is not a particularly long order. It runs to some 10 pages. I would encourage everyone watching perhaps to have a read of it, because what you will see very quickly, even from a word search of the document, is that there is no reference whatsoever to anything containing the term plausible breach. And that is because the court assessment of plausibility did not concern Israel's conduct in this case. It did not concern the specific allegations against Israel that genocide was being conducted. And we can come on to the absolutely horrific misrepresentations that South Africa sought to bolster its case against Israel with in due course. But what the court did in assessing plausibility is extremely important to be clear about. Its assessment of plausibility was about the claims being brought by South Africa, and at paragraph 54 of its judgment, it sets out that it considered whether those claims were plausible, whether there were plausible rights under the Genocide Convention that were being raised by South Africa. Now, that might sound like a technicality, like a splitting hairs differentiation between the notion of plausible claims or plausible rights versus a plausible breach, but it is critical because it is not correct to say, as many have done, on the basis of Friday's order, that there is a plausible case that has been found that Israel has breached the Genocide Convention. On the contrary, it is clear throughout the judgment that South Africa references Israel's position as encouraging the court to make exactly that assessment, to consider whether there is a plausible case for a breach of the convention. And the court declines that approach, and it adopts an approach based on previous case law, and this is case law that tracks back through footnotes across 15 previous cases to do with the question of plausible rights. But this court's interpretation of that is to assess whether the claims brought by South Africa in fact trigger the considerations of the Genocide Convention. It's the lowest imaginable threshold possible, I would suggest, but the manner in which it has been misrepresented highlights a couple of key factors. The first, it brings to mind this legal maxim, which I'm sure many will be familiar with, hard cases make bad law. But in this case, we're not just faced with a hard case, we're faced with a political case, an action that is essentially lawfare, using and abusing legal processes in order to advance a political agenda. And so that hard cases make bad law maxim has to be extended. And when we're faced with lawfare, I think it has to be recognised that lawfare initiatives and political agendas create not just bad law, but in many respects, law which is not law at all, which doesn't really make sense. The court's approach here has been essentially to state a tautology. South Africa brings claims under the Genocide Convention, and the court has found that it is plausible that the claims that South Africa brings concern the Genocide Convention. That, if you read carefully the judgment, is as far as the court has gone. Now, on that basis, it's not clear that there is any credible reason to issue provisional measures. And that leads us to a second real knotty issue, which has been seemingly grappled with by some commentators in the last couple of days. And that is, what are the provisional measures that the court has issued? If you consider the dissenting opinion of the Ugandan judge here, it becomes pretty clear what the court has done. She calls the provisional measures that the court has issued redundant, and she uses that term in particular because what the court has ordered is that Israel comply with its existing obligations under international law. There is no substantive advancement of the legal framework, the situation, by the provisional measures that have been ordered, with the exception that Israel is now required to provide a report to the court. That is not going to be a particularly onerous consideration for Israel to meet. But with that exception, that technicality of providing a report to the court, the other provisional measures simply restate the existing legal obligations on Israel, that Israel has been consistent in explaining that it is already complying with. That is why the Ugandan judge used the term redundant. Now, what does that tell us if the court is in fact making redundant provisional measures that aren't required to be made? Well, measures that simply restate the legal position. Sorry, go ahead.
Maybe that the court itself is redundant.
Well, unfortunately, it may be that we are heading in that direction, but having essentially come to a tautologous conclusion that the claims that South Africa advances under the Genocide Convention are indeed advanced under the Genocide Convention, and making a series of redundant provisional measures that simply restate Israel's legal obligations, I think the conclusion that we are left with is that this political exercise has been to advance South Africa's agenda against Israel in the international arena, and it has been successful in doing so because clearly it has changed the discussion here. It has encouraged the abuse of international legal terms like genocide in this context, and that has, of course, to be seen in the last few days when we have marked International Holocaust Remembrance Day as the most grotesque form of blood libel that could be advanced against the Jewish state. We are faced with an unreal and unbelievable situation, but one in which I think it's important to stress that the forces certainly that support Hamas, and Hamas has celebrated this decision, that in and of itself should be extremely telling to anyone who seeks to uphold international law and order. The consequences of this are not just problematic for Israel. They, I would suggest, problematic for all law-abiding states, and that's why the United States has been clear that this case is meritless. The UK Prime Minister has also called it wrong and said that it does not serve the cause of the Court of Peace. It's important that this is a UN court that has made this determination, and I'm sure this feeds into an awful lot of current debate and conversation about the approach that the United Nations has taken, the role that UNRWA has played in the perpetuation of the conflict and in the commission of real genocide against the Jews on the 7th of October. All of that is unfortunately part of the important context of what has led to the International Court of Justice making this what seemingly internally contradictory and redundant order against Israel on Friday. And it also has to be seen in conjunction with the parallel proceedings, which are underfoot and due to be heard in February. This is the General Assembly's application for an advisory opinion against Israel, presupposing breaches of international law against Israel, and seeking that the court opine on the legal consequences. So all of these avenues are targeting Israel for the purpose of seeking to isolate it internationally and abusing international law for that purpose.
So I think if I may, we'll put aside for a minute the idea of the advisory opinion, because that is really a program in and of itself. The abuse of that whole system in order to request, as you so rightly said, to ask for an opinion about a factual situation that is completely prejudicial and doesn't really exist, for a state and right that doesn't exist either, and then the court giving its opinion on both of those situations. But really, when I read the decisions of the courts and of the court and the different judges on just on the genocide issue and on South Africa, it really is a tremendously I think eye-opening and not a pleasant eye-opening situation. You have, for example, the German judge who says, well, we're only discussing here, as it were, South Africa's claim against Israel, almost excusing himself from saying, well, the actions committed on the 7th of October by the Hamas terrorists were themselves genocidal. You have what I particularly enjoyed was the opinion of the Chinese judge, who completely ignores the fact of what's going on with the Uyghurs and what her own country seems to be doing on the scope of re-education, if not genocide itself. And she's now coming to teach Israel as to what it should do and what it shouldn't do. The opinion of Justice Barak, who really summed up the whole argument, saying that Cain is now being absolved of his responsibility for the murder of Abel, and not only that, Abel is being blamed for his own death. The Jews are being blamed for their own death and for their own murder, and therefore we're committing a genocide. So they argue.
He stated it has wrongly sought to impute the crime of Cain to Abel. Absolutely, in the opening few lines of his.
It's really unbelievable things when you see the opinion of the Uganda judge, of Julia Sebutini, and really when you're looking there at really this developing situation over the last 50 years, where 50 years ago, Yasser Arafat, the head of the PLO, this well-known terrorist, was acting as the best man at Idi Amin's fourth wedding, and they were kidnapping and hijacking aeroplanes to Uganda. And suddenly you have 50 years later the Ugandan judge saying this whole claim of genocide against Israel is redundant. It's completely a waste of time. You cannot show, as the convention requires, you cannot show intent by Israel to carry out a genocide, and therefore you don't even go in through the doors. And so this is part of the understanding, and part of also the discussion that you and I had, Natasha, regarding the basics of giving the provisional orders in a normal court, right? I've spent a day or two in court previously, and you go into court and you make an argument on the basis of jurisdiction. That is the first subject that needs to be absolutely cleared up, because if the court that you've approached doesn't have jurisdiction on a certain subject, then the case gets thrown out and you move on in life. You never have a situation where the court decides, well, I'll possibly have jurisdiction based on the complaint that was put in. As you said, this tortious complaint where South Africa puts in a complaint that there was genocide. The court then decides, well, South Africa's made a complaint, so obviously we have jurisdiction, but specifically saying in the judgment itself, well, we haven't actually decided on jurisdiction. So
it is confusing, I think, and also difficult to follow in the judgment, the separate opinion of Aaron Barak, that despite his determination of a lack of jurisdiction, he would still go on to support provisional measures. And I think this is where it comes to the crux of what you were saying, which is the politics of the situation trumping the legal framework here, because his reasoning for the provisional measures that he did support is that it would foster better relations or improve the humanitarian situation. He generally thought that they were good things, and so he was going to jump on board with them. But that is putting the cart before the horse, of course, in the context of a court of law, if this is still to be regarded as one, where there has to be a proper legal basis for it. And I think, in particular, the dissenting opinion of the Ugandan judge highlights what the proper and appropriate thought process and the reasoning of the court ought to be. It shows what the court didn't follow, and it's extremely important that in the main court order, it's clear that the court hasn't considered intention as a separate aspect, and considered the evidence, of course, that they heard from Israel on the Friday of the oral hearings, that it is operated on a much, much lower threshold and simply considered the claims themselves and whether they are plausible.
But so on that subject of the oral hearings, this is also something that we've discussed. They seem to have been entirely superfluous. South Africa put in a claim. The court made a decision based on that claim. It basically ignored everything that was said during those oral hearings. So what was the point of them? What was that whole futile exercise, apart from a public relations fest for South Africa to present its case to the world, when it was already written and the judges could have made a decision in any case, because they ignored everything that Israel argued. Israel argued procedure, that there was no dispute with South Africa. They said, well, South Africa thinks there was a dispute, so that's enough. They argued there was an absence of intent. And the court says, well, at this moment, we're not even discussing the question of intent, which is really the basis of the Genocide Convention. It's there to stop acts which have the intent to destroy or in whole or in part a national or ethnical group. And if you don't have that basic intent and you can't show that intent, then all you have is a situation where the convention requires a certain threshold to enter through its doors, and yet the judges seem to be making an entirely different determination as to what that threshold is, and really to a great extent making the court, at least in my understanding, and the proceedings that was held into really a little bit of a joke.
You've also, I think, just put your finger on another aspect of the difficulties in terms of how the judgment, the order is being misrepresented. We've had some pretty prominent political commentators here in the UK saying, well, the court has ordered Israel to stop the killing, and therefore that is tantamount to an order for a ceasefire. I think the fact that, as you say, intention wasn't separately properly as it ought to have been considered as part of the plausibility threshold here, has led to this bizarre situation and this clear misinterpretation, if we're going to give people the benefit of the doubt, or misrepresentation, as it is perhaps more accurate to refer to it, that the first provisional measure, which concerns Israel taking all measures to ensure that the Genocide Convention is upheld, and listing amongst the acts that South Africa has alleged the killing of members of a particular group. In that respect, killing has to be seen in the context of the crime of genocide. And when one looks at the other authoritative texts, the translations of the Genocide Convention in French, in Russian, I think also, and in Spanish, that the word that is used instead of killing is murder. And that references, of course, the stark difference between the killing of individuals of a group with the intention of destroying a group in whole or in part, as envisaged under Article 2 of the Genocide Convention, as opposed to lawful killing of military targets in an armed conflict in compliance with international humanitarian law, and if the case may be, collateral damage as a result of proportional strikes, again, also in compliance with international humanitarian law and entirely out with the realm of Article 2 of the Genocide Convention. And the fact that the court has seemingly skipped over all of this and come to this decision, which is very difficult to rationalize, has, I think, directly led to the way in which so much of this order is being misrepresented. And all of that needs to be considered in the context in which, South Africa has brought this case. It is not by accident that South Africa is alleging genocide, despite the fact that that has no basis in fact or in law against Israel. It is doing so because that is the only hook that South Africa has to be able to bring this case against Israel. Israel is a signatory to the Genocide Convention, and it has accepted the jurisdiction of the court under Article 9. And as a result, it has also appeared at these hearings and engaged in this complete farce because Israel, as a country abiding by international law, a country of law and order, has seen it as part of its legal responsibility to do so and to call out the atrocious blood libels that it is that have been lobbed in its direction by South Africa. But that is carefully calculated on South Africa's part. And as I say, it is the legal hook that has caused it to bring these allegations of genocide. The fallout of that, and this is significant, is that it is giving further credence to these outlandish claims, and the language of international law of genocide, and likewise the other absurd claims that South Africa has advanced of apartheid, of ethnic cleansing, of occupation, of colonialism. These are all abuses of legal terminology to advance a particular political agenda. And as I mentioned before, it's not just Israel, I think, that will suffer as a result of this, but all law-abiding states, because of the abuse that international law is being subject to.
So really, one of the prime aspects of this whole lawfare idea is that you take these claims to court, you give them that veil of legitimacy, and hope to receive a judgment as the court gave down on Friday, and then you can use that judgment in a way that really perpetuates those same claims and carries on attacking Israel. I have to say that I didn't understand the decision in a way that that could be really interpreted in an alternative fashion. Once the court ordered the provisional measures, it means that, I think, if you look at this opinion, not with a fine legal comb, which is what most people do around the world, that really the public, the international community, don't know those finities and of the law, and the difference between the plausibility of the claims and the plausibility of the breach, and so it allows this whole use and abuse of the court as well, and the court seems to have played into that very happily. We're going to say that there is a plausibility to the claims, and we're going to issue the provisional measures, but really what we're going to say is that those same provisional measures are entirely redundant. So there's no real damage done to Israel. and there's no real damage done at all. But the damage that's being done, and the court, I think, is very aware of this, is very much in the sphere of international public opinion, in this ability of South Africa, of Hamas, to claim the victory and say, here, we told you that Israel is committing a genocide, and now the court has affirmed that position. That's something which the court seems to be either oblivious to, which I fear that can't be true. I can't believe that they were innocently allowing themselves to be used and abused, or they intentionally put themselves in that position as the tools in the hands of all of these terrorists and those who seek to attack Israel on any level. Why would the court allow itself to be abused by that? Sorry, Natasha, when in a situation, really, what can happen now as a result of that decision and the plausibility of the claim is that really Israel could now, just a thought, submit another 15 different claims against all countries around the world and demand those same provisional measures and really turn this whole court into even more of a joke. And that could be used by any country around the world. How can the court allow itself to be in that position?
I don't think conduct like that is in fact required of Israel to have the effect that you're referencing. The court is managing that very well by itself. And of course, Israel wouldn't do that because not only does it uphold international law, but it doesn't engage in the sort of lawfare that we have seen states like South Africa partaking in on the part of internationally prescribed terrorist organizations like Hamas. But of course, it's also important to recognize.
Until now, Natasha, adopting a passive approach and not by Israel using these same forums and using the proceedings in these same forums in the same abusive way as other countries do against us. Maybe that's the path that we need to go down. Maybe we need to expose the absurd nature of these decisions and really the baselessness of these claims against Israel and really put them into the other contexts to expose this to every country in the world. You can all be in the same dock with Israel if this is the standard upon which the court makes its decisions.
I think it's extremely important to be making that analysis and that assessment. And the fact that we've had Germany coming out against this, the UK, the US, shows that these democratic law-abiding states are not blind to the dangers of lawfare taking over these processes. Not least, of course, are the countries on the other side of the equation, and notably Iran last spring rejoined the compulsory jurisdiction of the court. And that would suggest that what we saw on Friday was perhaps predictable. There is a trajectory here of the plausibility threshold being lowered in the previous cases, notably Ukraine and Russia and the Myanmar case. So there was, to a certain extent, and I'm sure that this informed South Africa bringing this otherwise outlandish claim, an expectation that this is the way that the court would rule. And when one considers the reports of abuse that have been already flooding in towards the Ugandan judge for simply standing back and saying, this is the application of the law to the facts, and this is what the court should be assessing. I mean, it's extraordinary that such a cogent and carefully analysed judgment should occasion such abuse to one of the 15 permanent judges of the court. Of course, there were 17 that sat on this case because both Israel and South Africa appointed an ad hoc judge. But that perhaps goes some way to explain the phenomenon that you're asking me to address. Why is it that the court would be so far gone? I mentioned it was the United Nations Court, and it's important also in the context of the order that was made to consider, the mood music and the 84-page application that South Africa put forward, footnoted as it was, with a huge number of UN reports. And this is another key part of the process of lawfare. that is being waged against Israel, because it is not just the orders that South Africa was seeking. And of course, whatever the result in terms of the merit stage of the case will be, now that we know that this case will be proceeding, despite Israel's request that it be withdrawn from the general list. It is also the process of having outlandish reports by UN bodies, by human rights organizations, so-called, by UN special rapporteurs, given the judicial stamp of approval by the International Court of Justice through its consideration of these matters. And that is another very important outcome, a very problematic outcome, because it has the effect of generating faux evidence, which will undoubtedly be continued to be used against Israel in other judicial fora, including we've spoken at length in the past about the International Criminal Court, which has jurisdiction over individuals, despite the fact that it has no jurisdiction vis-a-vis Israel, because Israel is not a party to the Rome Statute. The current prosecutor, Karim Khan, has taken an active interest, especially in the last few months, as to the situation that has been developing both on the 7th of October in Israel and subsequently in the Gaza Strip. So there is a great deal more to come in this respect, and it's all the more important in those circumstances that those upholders of the rule of law and of international law more generally, and those who seek to push against lawfare initiatives and the politicization and abuse of international law, do so even more robustly. And speaking truth to power really counts at this moment.
And that's exactly it. I mean, you have being quoted in the decision, the UNRWA, the United Nations specific organization that deals with the Palestine refugees. This is and the reports of the organization being given this real judicial stamp of approval, when in reality, and that's what's happening really in the last few days that have been developing, it turns out that UNRWA employees were actually involved in the October 7 massacre. We know that UNRWA has played a tremendous role in the education of the Gazans and preparing them really for this role of carrying out the massacre. We know that UNRWA is a branch of, and unfortunately, a branch of Hamas. It's dominated by Hamas in the Gaza Strip. Any aid that goes in through UNRWA goes to Hamas, and then Hamas gives it out. And so this organization, which is really a part of Hamas to a great extent, is the one that's now being quoted by the court and giving validity to the claim of genocide against Israel, even though they are the arms of Hamas itself.
But a couple of things, I think, just to pick up on that. You're absolutely right. Philippe Lazzarini, the head of UNRWA, and there have been significant calls for his resignation on the basis of the recent revelations, is directly quoted in the court's order. But of course, so is Hamas, when the court references this supposed figure of 25,000 casualties, which would come from the Hamas Ministry of Health. And that is even quoted without attribution. It is said that the figures cannot be independently verified, but the wording was something like recent information indicates, which is utterly extraordinary that the International Court of Justice would take the word of a terror organization, especially in circumstances where, of course, that 25,000 figure that is quoted has clearly been dramatically inflated. And we just look at the 17th of October and the jump of 500 casualties supposedly coming out of the Al-Ahli hospital car park bombing. After that incident was utterly discredited, and the way that the international media reported it was an utter disgrace. But after it was discredited, that figure was never revised. So the fallibility of these figures and the lack of trustworthiness is the point number one to raise. But the figures also make no distinction between combatants and civilians. And we know that the IDF has put out its information that it has killed over 9,000 terrorists. That is not reflected in the figures that the court quoted. Neither is the cause of death. Because we also know that Hamas has been shooting its own citizens, shooting Palestinian civilians that are seeking to flee.
Thousands of the rockets that they fired fell in the Gaza Strip, as in their incident in the Al-Ahli hospital.
Yes, And that also. So the fact that those reports are being considered by the court and have even been repeated in its order of Friday is utterly extraordinary. It further discredits, unfortunately, the order and the position that the International Court of Justice has taken in this regard. But when we come to consider UNRWA, I mean, these recent allegations are the tip of the iceberg. NGOs have been reporting on the complicity with Hamas for well, certainly since the Hamas takeover in 2006, 2007. But the purpose, of course, let us not forget, of UNRWA when it was established was to keep alive the genocidal war of 1948 waged against Israel, with this invention of a right of return, the perpetuation of generation after generation of Palestinian refugees, not for the sake of the Palestinians. They have been used as pawns and appallingly abused by the Arab world that has sought to perpetuate their refugee status. And the whole purpose, of course, of UNRWA has been to wage a genocidal war against Israel. So it can hardly be surprising that now their staff are accused of actively participating in the 7th of October massacre, not least when UN Watch has put out Telegram chats involving 3,000 UN UNRWA teachers who have been celebrating the 7th of October massacre and celebrating Hamas terrorism. And when we have seen textbooks highlighted repeatedly by Impact SE that promote martyrdom, the teaching of kindergarten children that the highest calling in life is to become a suicide bomber is child abuse. And NGO Monitor, another organization, as well as the Foundation for Defense of Democracies and the Jerusalem Center for Public Affairs, have put out repeated reports highlighting the abuses by UNRWA of the Palestinian people themselves and the promotion of hate and the perpetuation of this conflict. I hope that after the 7th of October massacre and after this new evidence, the eyes of the international community have been opened to it. We've seen an unprecedented number of countries that have called for the suspension of aid, but we have also seen very worrying justification of UNRWA's support for terrorism, and this equally worrying, hands being held up. Well, what on earth can we do? What other alternative is there to provide support and humanitarian assistance to the Palestinian people? Well, find one, because continuing to support UNRWA and the corruption of the Hamas leadership, who have been siphoning off funds and they're sitting in the bank accounts that they hold in Qatar and other places around the world, is not an answer. That is not serving the cause of the Palestinian ordinary civilians that deserve humanitarian assistance, that deserve new leadership, and it is not serving the prospects of peace in the region more generally.
Was it a mistake to play along with this whole farce, Natasha? Should Israel just have said, you people have already made your decision. This is a biased court. It is an illegitimate court. And therefore, we are not going to play along as we are doing, as we did with the advisory opinion in 2001, 2003, through 2001 through 2004 on the security fence, and now also in this parallel advisory opinion. Should we just have said, you know what, we're not going to play your game anymore?
There are a number of differences that I think it's important to highlight between previous cases where Israel hasn't participated and this one. A bilateral case of the sort brought by South Africa against Israel is binding, the determination of the court, but for some ridiculous assertion that Israel doesn't have a right to self-defense, something that would be palpably incorrect in international law, given the, amongst other things, the recognition in Article 51 of the UN Charter of an inherent right to self-defense. So absent anything of the bonkers variety, then the rulings of the International Court of Justice in a bilateral dispute such as this are considered to be binding. Israel, as I indicated, is a country of law and order, and that also informs the decisions that are taken by the Ministry of Foreign Affairs, the Attorney General's office in this regard. To a certain extent, I also think it has caused many of the decision makers in this process to believe that there is the possibility of a fair hearing at the International Court of Justice. That is also deeply rooted in an Israeli upholding of the law and an expectation that international legal institutions will do likewise. The difference between this sort of case and the previous advisory opinion on Israel's security barrier, the so-called Wall opinion in 2004, and the current opinion that is being sought by the General Assembly from its reference to the court in December 2022, is that the advisory opinions of the court are not legally binding. And importantly, it is an inappropriate use of the advisory opinion procedure to ask the court for such an advisory opinion on essentially a bilateral dispute on a matter in which a party ought to be able to make its case heard. And on that basis, Israel's consistent position has been the court simply doesn't have jurisdiction. Now, when we consider the outcome of that position in 2004 and the nature of the opinion that was given by the International Court of Justice in the Wall decision, the Wall opinion, forgive me, it's clear that the court simply didn't have the correct information in front of it. And the opinion of the International Court of Justice was dealt with pretty robustly and a very strong analysis, I would suggest, by, in fact, the previous president of the Supreme Court of Israel, Aaron Barak, when it was sitting as the High Court of Justice, considering the security barrier. There was an analysis of the failings of the advisory opinion of the ICJ, that it didn't consider the terrorism threat that Israel was under, the wave of suicide bombings that the wall had, the security barrier had been built in response to, the effectiveness of that. And it compared the approach of the International Court of Justice, I think very impressively, with the approach of the High Court of Justice in Israel, which balanced the rights of Israeli citizens to security against the rights of those that would have been impacted by the proposed route of the security barrier, and it did so on a almost meter by meter basis, determining where the balance should lie and where the route of the barrier should be established. That is the difference, and I think equally, we're going to see, unfortunately, inevitably, the International Court of Justice making a decision on the basis of misinformed positions and the lack of information. In fact, UK Lawyers for Israel have put together a submission together with Elnet to the International Court of Justice, highlighting this very point, saying that it simply does not have the appropriate information in front of it to opine on the issues that it has been asked to address. And on that basis, I think Israel is right not to engage, because it is an entirely misguided, inappropriate process and lacking the appropriate jurisdiction. It is not an appropriate use of the advisory opinion mechanism.
And yet, in this case, we did participate. We did provide the court with the necessary real information of what's going on, of Israel's both actions and its intentions, both in evidence and in statements and in everything that the court could have required, really, to make a normal decision. And nonetheless, the court decided as it decided against Israel, completely negating anything that we said. So again,
well, I just highlight a slight difference that I have with that, and I think that the court didn't decide. It hasn't decided yet. It's decided to tread this line where it hasn't made any determination on the material that Israel has provided. So far, that hasn't been taken into account. Was Israel correct to have engaged in this process? Well, given everything I said about Israel having accepted the jurisdiction of the Genocide Convention, and highlighting the problems with South Africa's claim that there was in fact a dispute here, Israel has essentially acted as a responsible state, abiding by international law and putting its case forward. It's deeply lamentable that the court has decided that as part of the provisional measures stage, it doesn't need to consider what Israel has advanced.
Why is this case going to take so long, Natasha? The estimates now, and really based on previous experience, that these cases before the courts drag on for 2, 3, and 4 years. Is that something that we're going to see here? Why does that have to be the case? That really means that for 4 years, ostensibly, the international community, public opinion, the terrorists will be able to continue claiming that the court found that Israel was already committing a genocide before it even discusses anything else. So, why does that take so long? And B, what recourse would Israel have were the court to find eventually that there really was no intention here to carry out a genocide? There was no basis for the claim itself and issuing any of the temporary measures. How can Israel really demand repairing the damage that's been done in public opinion from the court?
Just before I answer, I'm going to apologize for the buzzing. It is actually my Red Alert app. So it is possible to have the app outside of Israel, and I do, and I routinely seek to mention when there are more air raid sirens if they occur in the course of interviews that I do. So apologies if the buzzing was audible then, but that was what it was, and I think that's more infiltration of UAVs in the north of Israel, unfortunately. So far as the timing of this case is concerned, this is just how long matters in the International Court of Justice take. The docket, if as the Americans would say, the general list is not a particularly heavy one. There are only a few cases that the International Court of Justice hears, and they inevitably take a substantial amount of time because of the nature of the issues involved and the nature of the material. In terms of the ongoing circus here, however, I won't be surprised if South Africa does seek to challenge, Israel's purported compliance with the provisional measures going forward because of the bizarre web that the court has decided to weave here in basically ordering redundant measures, those that Israel is already complying with, and fudging the plausible rights or plausible claims that it purports to have found. Then there's ample room for South Africa to continue its harassment of Israel in the context of the International Court of Justice. And in that respect, it is serving its purpose. And this brings me to the second question that you raised. How do we go about repairing the damage if Israel is finally able to vindicate itself? Because I think here the damage is already done. The international discourse has occurred. The blood libel is rife, and the misinformation that the court has purportedly found that it's plausible that Israel is committing genocide. I mean, that falsehood is being perpetuated even by people who should know better. People who have claimed to have read this judgment, claimed to have read the order that the court issued on Friday, and are commentating and saying that the court has found it is plausible that Israel is committing genocide, are misrepresenting what the order of the court says. But that is damage that is impossible to undo, especially because it does seem that there is a readiness to believe falsehoods against the state of Israel. I mean, we see this on full force frequently on social media, but that kind of TikTok generation that unfortunately is now coming to make the decisions and the determination across international broadcast media, this is where they're getting their education from. This is where they're getting their supposed legal analysis from, and that clearly makes the position much harder to contend with, to push back on. And I think it does mean that the damage that we're seeing will ultimately be irreparable.
Natasha, unfortunately, whilst I believe that we could go on discussing the decision for many, many hours, unfortunately, our time has more than run out. So I just want to thank you for joining us. Thank you for the analysis. I hope that we've provided our audience with a better understanding of what exactly happened in the court, what was decided by the court. I mean, the idea of these briefings isn't just to sit here and talk to people, but really to provide our audience, to provide a wider group of people with the ability, the understanding, and the context to really go and combat all these claims that are being made against Israel. When you hear these claims being made on your campus in America, know that you can quote Natasha, know that you can have the full analysis. We'll put up, obviously, we have every day, the briefing is saved. It doesn't only go out live on our YouTube channel, which you can also subscribe to and join. It goes up onto the JCPA website, and it's there for everyone to use as this really, I would hope, a tremendous resource to understanding, or to better understanding the context of what's going on, and to really empowering people to know what to argue, how to argue, and on whom they can rely. This is part of the idea of the briefing. And so thank you again, Natasha, for joining us. Thank you to our audience for joining us. We will be back with you again tomorrow at 4 o'clock Israel time. In the meantime, just remember, not everything that you're hearing on TikTok is true. Israel has not committed a genocide. We don't need, and we wouldn't need the court to tell us or to confirm that. That is part of our fundamental beliefs as a country, as a people fighting for our rights, having been the subject of the worst genocide in human history. So just remember that Israel isn't the monster that people are claiming it to be. We're fighting to defend our population, the Jewish people, against the genocidal, homicidal terrorists, and not the other way around. And it doesn't matter the falsities that are promulgated by international organizations, UN organizations, quoting themselves, quoting the terrorists. The truth at the end of the day is very clear, and it's on our side. So on that note, everybody, stay safe, have a good evening, have a good day wherever you are around the world, and we will see you again tomorrow. Natasha, thank you.
Thank you so much. It's good to be